Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. In Adam Montgomery's case, one of the most vexing issues is how does a guy who doesn't have access to a vehicle manage to transport a dead body and dispose of it without leaving any trace? And of course, the answer to that is that he essentially used a friend to rent a U-Haul and using the U-Haul disposed of the body. That's the state's proof so far. Now, yesterday, or I should say on Friday, they put the person who rented the vehicle up, and he gave probably one of the most uninspiring direct exams I have ever seen. In fact, let's take a look at that now.
Did you provide him U-Haul keys?
Yes, sir.
Let's talk about that interaction. Can you tell the jurors where you were when you gave him the keys and what specifically he told you?
Myself and Brittany Bedard gave the keys to Adam Montgomery, which he was staying at the Econo Lodge on the first floor. After that, Adam Montgomery and myself went outside to smoke a cigarette. He was pacing back and forth. He said he effed up, and I asked him what he meant, and all he could say and repeat was he effed up.
And you said he repeated that?
Yes, sir.
How many times did he repeat?
4 or 5 times.
Did you ask him to clarify?
I did, and he did not.
Did he say anything when you asked him to clarify?
All he kept saying was that
Where was Kayla during that conversation?
Kayla was in the first floor at the Econo Lodge with Brittany.
And I think you said this already, but at that point, when you went out to smoke the cigarette, you'd already given him the U-Haul keys.
Correct.
At any point during your time with that at the Econo Lodge, did you see the defendant drive the U-Haul?
I did not.
At some point, did you go back to your own room with Miss Bedard?
Yes, sir.
And prior to going back to your own room, had you seen him drive the U-Haul at all?
No, I did not.
Was the sun out when you went back to your own room, or?
No, sir. It was still nighttime.
It was nighttime.
Yes, sir.
Do you know why the defendant didn't want you messaging stuff to him about a U-Haul rental?
No.
And let me back up. You said earlier you didn't know what he was using this U-Haul for.
Correct.
Did you ask him?
No, sir.
Why not?
Honestly, I didn't think I had to because I saw all his belongings packed up, and during the day, he said he was having problems with DCYF, so I kind of figured that he was moving.
One thing that always makes my ears perk up when somebody says it is a prelude like honestly, because usually it means anything but honestly. Honestly, I didn't think I needed to. He says the guy has screwed up, and that's all he'll say, and you don't think you need to ask him why he's moving, why he's going to use your truck? That really strains credulity pretty badly, I think.
And were you aware that he'd just moved into that apartment?
No, sir.
Did you ask Kayla what the U-Haul was for?
I wasn't allowed to talk to Michaela.
Why weren't you allowed to talk to Kayla?
I didn't ask.
Mr. Beach, did you ever meet a child named Adam Montgomery?
No, sir. No, sir.
Thank you, Mr. Beach. No additional questions for you, sir.
Well, I did a short yesterday emphasizing that this is a guy who knows a guy and knows how to keep his mouth shut. But he isn't protecting Adam Montgomery here. He's protecting himself. There is a statute in New Hampshire that deals with accomplice liability. Now, an accomplice is somebody who aids in the commission of a crime. And when you aid in the commission of a crime, you become subject to the same level of punishment and the same essential conviction as the underlying crime. So, here is what the New Hampshire statute says. It's under criminal conduct or criminal liability for conduct of another. A person is guilty of an offense if it is committed by his own conduct or by the conduct of another person for which he is legally accountable, or both. A person is legally accountable for the conduct of another person when, acting with the kind of culpability that is sufficient for the commission of the offense, he causes an innocent or irresponsible person to engage in such conduct, or he is made accountable for the conduct by such other person by law defining the offense, or he is an accomplice of another person in the commission of an offense if, with the purpose of promoting or facilitating the commission of the offense, he solicits such other person in committing it, or aids or agrees or attempts to aid such other person in planning or committing it, or his conduct is expressly declared by law to establish his complicity. So, in other words, this statute covers the conduct where, following the offense, if you aid in covering it up, if you aid in preventing its discovery, you can be considered an aider and an abetter. That statute is later interpreted in a case called State versus Kevin Merritt. And in that case, there was a gentleman who accompanied a woman, and the woman had stolen some credit cards. And after stealing the credit cards, she manages to go with her boyfriend and buy a whole bunch of clothes and jewelry. And he is charged with accomplice liability, 4 counts of it. And the first count is for an interaction where the defendant did nothing more than stand at the side of the person who actually was using the credit cards. So here is what the state's case says about that. The indictments allege that the defendant acted in concert with Higgins in the fraudulent use of the Driscoll and Dennis credit cards. The trial court instructed the jury that acting in concert meant accomplice liability. Under our criminal code, a person may be legally accountable for the conduct of another person if he is an accomplice of such other person in the commission of an offense. A person is an accomplice if, with the purpose of promoting or facilitating the commission of an offense, he aids or agrees or attempts to aid such other person in planning or committing it. In reviewing the sufficiency of the evidence, we determine whether, based on all the evidence and all the reasonable inferences when considered in the light most favorable to the state, any rational trier of fact could have found beyond a reasonable doubt the defendant was a voluntary and active participant in each of the fraudulent credit card transactions. The defendant first contends that no rational jury could have found him guilty as an accomplice for the Jordan March jewelry purchase because he was merely present in the store and did not take affirmative steps to satisfy the actus reus requirement. We agree. The concept of accomplice liability necessitates some active participation by the accomplice. Mere presence at the scene of the crime is insufficient. And so it goes on a little bit and says, it can be sufficient if you do other things, but that's not what happened in that case. Well, now that helps explain a little bit about why this particular witness would essentially decide that he didn't, he's Sergeant Schultz.
I know nothing. Nothing.
I know nothing is exactly right here. He knows nothing because basically if he had known anything, he would have been guilty of accomplice liability. Now, it's not accomplice liability to murder, obviously, because he had no part in helping Adam Montgomery allegedly kill his daughter. Rather, what he has accomplice liability for is essentially mutilating a corpse, hiding the corpse, disposing of it, whatever it was that Adam Montgomery did when he took that U-Haul from the friend of his who rented it. Now, because he had a fairly cogent explanation for why he didn't think anything of it, I think there is a good chance that probably dominated the state's thinking about why he might not want to be indicted, why they might not want to indict him for aiding and abetting. But what's really telling here is when he says, I couldn't ask Kayla anything because, I was told I couldn't talk to her. Well, did you ask why? Nope. Again, he didn't want to know. His friend came to him and said, you need to rent this truck for me and you need to not ask any questions. And that's exactly what he did. Now, I would suspect that if they put this to a jury, knowing what happened in this case, there's a good chance he could have been convicted of aiding and abetting. But of course, the state wanted his testimony. The state got his testimony. And as a result, he's not going to face any charges for that. But I do think that aiding and abetting is certainly something that Kayla Montgomery could have been charged with, even though she didn't actually kill, allegedly. Anyway, her testimony suggests that she did not kill Harmony Montgomery. There is a good chance that she aided and abetted. So I had a long weekend, and I hope you all have had a nice long weekend, and look forward to putting up more case information from this when they come back into court on Tuesday morning. Thank you so much for watching. Have a terrific day, and catch me down here at the beach again next time. I try very hard not to be like all those other YouTubers who open up every video by asking you to subscribe before you've even seen the content. But now that you've gone a few minutes into the content, if you find this interesting and helpful, please subscribe. I'd consider it a personal favor. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.